Hello and welcome to Legal Studies TV. It's been a very long time since I've been here. Today I'm very glad to be with you today. Today I want us to talk about an interesting topic, which is rights of female employees getting pregnant. So the question here is, at what point can a female employee get pregnant? Our laws do not impose any restrictions on female employees as to when to get pregnant. In fact, it is the right of every female worker to get pregnant at any time she so desires. Okay, so if you go to the Constitution under Article 17, Article 17 of the Constitution, it talks about equality before the law and also speaks against discrimination of all kinds. So now let's look at what the Constitution says. The Constitution says under Article 17 of the 1992 Constitution. So Article 17 Clause 1 of the 1992 Constitution says, all persons shall be equal before the law. Okay, so if you go to Clause 2, it also says, a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. So that is what Clause 2 of Article 70 of the 1992 Constitution says. If you read further to Clause 3 of Article 17, it also says that for the purpose of this article, discriminate means to give different treatment to different persons attributable only or mainly to their respective descriptions by race, place of origin, political opinions, color, gender, occupation, religion, or creed, whereby persons of one description are subjected to disabilities or restrictions to which persons of another description are not made subject, or are granted privileges or advantages which are not granted to persons of another description. Okay, so this is what Article 17, Clause 1, 2, and 3 says. Okay, so in a landmark case, of Shrad and two others versus the Ghana National Fire Service and the Attorney General, the Human Rights Division of the Accra High Court, presided over by Justice Anthony Yeboah, as he then was, declared as unlawful regulation 33(6) of the condition of service of the Ghana National Fire Service that DEBES service women from getting pregnant within the first 3 years of their employment. Okay, so this was a landmark case that was held in, I think, 2018. Okay, between Shrad, Commission for Human Rights and Administrative Justice, and two other female officers of the Ghana National Fire Service versus Ghana National Fire Service and the Attorney General. Okay, so that was the case. And in this case, the court presided over by Justice Anthony Yeboah declared that it was unlawful, or Regulation 33, Sub-Regulation 6 of the Condition of Service was unlawful, and that Regulation debars service women from getting pregnant within the first 3 years of their employment. Okay, so now I would like us to look at before we go into the case, let's look at Regulation 33, Sub-Regulation 6 of the condition of service, of the old condition of service of the Ghana National Fire Service. In fact, this um, condition of service is now old because the Ghana National Fire Service is now having a new condition of service, and they have scrapped this regulation from their new condition of service. And the new condition of service was passed by Parliament, I think, in 2020. So it is no longer in use. But before the case went to court, this condition of service was in place. So let's look at what Regulation 33, Sub-Regulation 6 of the then condition of service of the Ghana National Fire Services. So it says, and I quote, a female employee shall not be dismissed on the ground that she is pregnant, provided she has served the first 3 years. Okay, so this is what Regulation 33, Sub-Regulation 6 of the condition of service of the Ghana National Fire Service provides, and which the court presided over by Justice Anthony Yeboah declared to be unlawful. Okay, so coming back to the case. Now let's come back to the case. Okay, so this case involved two female officers of the Ghana National Fire Service who got pregnant and was dismissed by the service based on Regulation 33, Sub-Regulation 6 of their condition of service. And Regulation 33, Sub-Regulation 6 is what we have just looked at. Okay, it's what we have just looked at. So these two female officers, aggrieved by the decision of the service, petitioned SRAJ, and SRAJ in turn sued Ghana National Fire Service and the Attorney General. Now let's look at the petition of the female officers and to SRAJ and the case filed against Ghana National Fire Service. Okay, so Ms. Fusu and Ms. Hammond, however, became pregnant within the first 3 years of their employment and were accordingly dismissed by the Ghana National Fire Service in 2014 and 2013 respectively. Aggrieved by their dismissal, they petitioned the Commission on Human Rights and Administrative Justice, SRAJ, which in turn sued the Ghana National Fire Service and the Attorney General at the Human Rights Court. The applicants, SRAJ, Ms. Fusu, and Ms. Hammond, argued that the dismissal and Regulation 33, Sub-Regulation 6 were against the fundamental human rights of the two women, as stipulated in Article 17 of the 1992 Constitution. So I think Article 17, we have already looked at it. Okay, but let's go back to it again. So particularly Article 17 clause 2. Article 17 clause 2 states, a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. So as I first read to you, okay, it is also been stated here. So now that we have looked at what the petition entailed. Now let's look at the defense put up by the Ghana National Fire Service and the ruling of the court. Okay, so in its defense, the Ghana National Fire Service argued that Regulation 33, Sub-Regulation 6 was necessary due to the vigorous physical training that new employees went through to adequately equip them for their tasks. Okay, so this was the argument that Ghana National Fire Service made in court to put up as a defense. Okay, so they were saying that they argued that Regulation 33(6) was necessary due to the vigorous physical training that new employees went through to adequately equip them for their tasks. Okay, and this was let's quote what they say. What they said in the court proceeding, and I quote, that vigorous physical training that the employees go through may adversely affect the fetus and the would-be mothers if these employees end up pregnant. A measure such as dismissal is made part of the condition of service to prevent this danger, it stated. So this was the argument that Ghana National Fire Service put up in court, that, well, because of the vigorous training, the vigorous physical training that new employees had to go through in order to equip them for the job. They had to, they had to what do you call it? It was necessary. It was necessary for that provision, which is Regulation 33(6), to be enforced in order to prevent such dangers from happening. So that was the argument that Ghana National Fire Service put up in court. Now let's look at the ruling of the court, the decision of the court. Okay, so in its judgment, the court held that Regulation 33, Sub-Regulation 6 was discriminatory to women on the basis of gender, which is frowned upon by Article 17, Clause 2 of the 1992 Constitution. So basically, this was the ruling of the court that that regulation, Regulation 33(6) of the condition of service of the Ghana National Fire Service was discriminatory to women on the basis of gender, which is also frowned upon by Article 17(2) of the 1992 Constitution. Okay, so that was the decision of the court. Now, let's look at what Justice Anthony Yeboah said, and I quote, "The second and third applicants, Grace and Thelma, are women who are protected under Article 17 of the 1992 Constitution. The right to family includes their right to be pregnant, and they are entitled to the right to choose when to become pregnant." This is very, very interesting. I want to emphasize on this point that the justice presided the justice that presided over this case said. I'm talking of the late Justice Anthony Yeboah, and he was saying that the second and third applicants, which is Grace and Thelma, are women who are protected under Article 17 of the 1992 Constitution. And here, this is very key. He said, the right to family includes the right to get or to be pregnant, and they are entitled to the right to choose when to become pregnant. Okay, so this is what the court said, that everyone has the right to family, and the right to family includes the right to be pregnant, and these women are entitled to the right to choose when to become pregnant. So no, employer can tell you that once you join this his organization, or you are employed in that organization, you should wait till some number of years before you can get pregnant. That is a total violation of the 1992 Constitution. And as the court said, every person has the right to family. You have the right to make your own family, and this right includes the right to be pregnant, or the right to impregnate someone, not just for women, but even as a man, the right to impregnate someone or your wife, the right to procreate. So for any employer to tell you that you have to defer your pregnancy for a number of years, that will be a discrimination. That will be a violation of the fundamental human rights of such employees. Okay, so this is very, very, interesting. Okay, so the court was also of the view that unlike their male colleagues, Regulation 33(6) negatively affected the marriage and sex life of the women during their first 3 years of employment. Okay, so this is what the court also said. The court also was of the view that unlike their male colleagues, now you see what the regulation 33 clause, regulation 33 sub regulation 6 of the condition of service of the Ghana National Fire Service, meant was that only female employees are not allowed to get pregnant within the first 3 years of their employment, but rather male officers can impregnate others. So the court was of the view that this negatively affected the marriage and sex life of the women during their first 3 years. So this clearly shows that it was discriminatory. How can you make a provision in your condition of service which will prevent female officers from getting pregnant for within a certain period of time, but allowing their male, the other colleagues, the male officers, to allow them to get, other women pregnant at their own choice. But for the female officers, you are preventing them from getting pregnant, within a certain time frame. So this was total discrimination. Okay, yes. So that was what the court said. The court also added, the women employees are therefore subjected to adverse treatment. The Ghana National Fire Service discriminated against the second and third applicants, Grace and Thelma, on the ground of gender. Okay, so this was the ruling of the court. That was the ruling of the court. Okay, so it's very, very clear that you cannot impose certain restrictions on women, female employees, with regards to their sex life when to get pregnant. It's total discrimination, and it's a discrimination based on gender. Okay, so the court also noticed that there was more discrimination towards that provision or that regulation in their condition of service. Okay, so let's look at the other discrimination that the court pointed out. Per the documents presented to the court on June 12, 2014, the GNFS recalled all fire service women who were asked or who were sacked under Regulation 33(6), except Grace and Thelma, and allowed them to wear maternity dress and also gave them maternity leave. You see, so the same year that these women were dismissed, the service recalled all the women that have been dismissed by the service based on this regulation and leaving just these two female officers without recalling them. So this was the total discrimination, and the court observed that in its judgment the court further held that it was discriminatory for the GNFS, which is the Ghana National Fire Service, to recall other pregnant women with the exception of Grace and Thelma. Okay, so this was what the court said and observed, which made it more discriminatory. Now let's look at what the judgment that the court gave. Some of the exact judgment and compensation that the court gave. Now the court said, and I quote, "The exclusion itself amounts to another act of unjustifiable discrimination. The second and third applicants, Grace and Thelma, are entitled to compensation for the unwarranted institutional onslaught on their fundamental human rights, the right to work and freedom from discrimination." Okay, so this is what the court said. It is hereby ordered that the GNFS pays each of the second and third applicants, which is Grace and Thelma, compensation in the sum of 50,000 Ghana cedis for the trauma and inevitable inconvenience of the wrongful dismissal. So Justice Anthony Yeboah ordered that the GNFS should compensate these women, to the sum of 50,000 Ghana cedis each for the trauma that and the inconveniences that the service, put them through due to that wrongful dismissal. Okay. Yeah, so the court declared so, okay, and gave that these orders to the Ghana National Fire Service to comply with. Okay, so let's look at some of the statements that the court made. It was also said by Justice Anthony Yeboah that Regulation 33(6) of the Condition of Service of the Ghana National Service is discriminatory in effect, unjustifiable, illegitimate, and illegal. Okay, so the court also made this, proclamation. Apart from the compensation, the court also ordered the GNFS to reinstate Miss Grace Fusu and Miss Thelma Hammond, the two women, and also pay them all their salaries and benefits that had accrued during the period of their dismissal. This is interesting. It further awarded cost of 10,000 Ghana cedis against the GNFS. Okay, so the court ordered that the GNFS should compensate the two female officers 50,000 Ghana cedis each, and also ordered that these two female officers be recalled or be reinstated back to the service and be paid all their salaries and benefits that had accrued during their period of dismissal. You see, this is very interesting and very, very punitive to the service. So now, this is a very landmark case, which, prove that female employees have the right to get pregnant at any time they want, and no employer no employer whatsoever has the authority or the power to impose any restrictions, on their, um, sex life, or with regards to female employees what getting pregnant within a certain time frame. Okay, so this is all that I have for you today, and I think it's very interesting, and we have learned a lot out of it. So those organizations and employers who tend to, at times, some when they are employing female employees, they let them sign bond. You sign bond that you are not going to get pregnant, within maybe a certain time frame. All is illegal, is against the law, is a violation and contravention of the 1992 Constitution, as we read under Article 17, Clause 2. Okay, so that is it for today. Thank you very much. Thank you for paying attention and listening to me. You can subscribe to the channel on YouTube, Legal Studies TV, with Eric Frimpong attached to it. You can also watch my videos on Facebook and Instagram. Thank you very much.